Ready? 3, 2, 1, start. In its rejoinder, it has been submitted by the petitioner that although the private respondent had submitted its defective bid in the sense that it had submitted unfilled undertaking of the bid, which is not permissible. Stop. The private respondent had actually submitted the representation dated 6/5/2019 followed by a representation dated 4/11/2019 and the omission to record about their receipts in the receipt register by the FCI cannot be the basis to claim that the representations were not submitted by the petitioner. Stop. Moreover, the true copies of the representations available with the petitioner are just marked as signed, but the representations were submitted with the original signatures. Stop. Since the counsel appearing for the FCI submitted during the course of hearing on 9/6/2020 that the representations were never submitted to it, the petitioner submitted another representation dated 10/6/2020 requesting for conducting an enquiry into the misplacement of the documents. Stop. The petitioner being a participant in the tender process, it could challenge the award of contract. Stop. Since the bid submitted by the private respondent being defective, the letter of acceptance issued to it in violation of clause 5 within bracket 2 of NIT is illegal. Stop. The scrapping of the NIT was the correct approach as all the bidders were found technically disqualified. Stop. The CWP number 259 of 2020 reasoning given by the Grievance Redressal Committee FCI regarding retrospective operation of the corrective measure is unfounded and the decisions are to be taken in accordance with the MTF and NIT. Stop. The contention that the speaking order dated 21/11/2019 should not have been applied retrospectively indicates that the order dated 26/5/2020 is illegal. Stop. The submissions of Shri H.S. Pannu, learned senior advocate appearing for the petitioner, are that the private respondent had submitted a defective bid by leaving certain pages blank in the tender submission undertaking, but its bid was allowed as technically qualified while the petitioner's bid was technically rejected. Stop. In other words, the bid of the private respondent was liable to be technically disqualified, as clause 8 of the MTF indicates that the tender which does not comply with the instructions shall be summarily rejected by the FCI. Stop. Being aggrieved by the declaration of the private respondent's bid as technically qualified, the petitioner submitted two representations dated 6/5/2019 and 4/11/2019. Stop. It has further been submitted by him that the scrapping of the NIT wide letter dated 24/12/2019, despite the letter of acceptance having been issued in favor of the private respondent, was the correct approach, and therefore the petitioner did not have any grievance at that point of time. Stop. Over.